Welcome everyone, and welcome to those who join us online. As Jennifer did mention, this is one of the SAICE events, Werksman Attorneys and Koleko. So as Koleko, we are uh, transport engineers, and also we do town planning as well. And when Avi and Jennifer met, they discussed this event. And our first one that took place was in Cape Town in June. So we decided, why not have a second one? We'll actually discuss further. And one thing I remember from the first event was that there was a lot of laws that I didn't know actually, hey? It was acts of this and that and labor laws and ESGs and so many alphabets of those who were there actually attending virtually or in person. So today, as Jennifer mentioned, we've got our panelists and we'll be actually delving into ESG, talking about navigating the legal landscape of construction in South Africa. So, Jennifer, over to you.
All right, so first on the lineup, let me just summarize. We've got three speakers or three separate presentations. We first have Jacques van Wyk, who's flown up from Cape Town today to talk to us about sectoral regulations in the employment in the construction space, which are in the pipeline and which will impact on the construction sector quite meaningfully. So we would suggest that you all take cognizance of these regulations for planning purposes. Also, yeah, actually, let me just pause there and invite Jacques up to talk to that. And let me also just say that Jacques will take his questions immediately after he's presented, because with three talks in a row, we might find ourselves forgetting what was important in discussion one. So, but we'll ask to confine it to a maximum of 3 questions, because we are quite limited for time. Thank you.
Thanks, Jen. So I'm going to talk today about the Employment Equity Act, specifically the draft regulations that are still draft regulations since we last spoke. There seems to be a little bit of a lack of momentum when it comes to the promulgation and coming to force of these regulations. However, it's good to know and good to plan for. And these draft regulations, the ones I'm focusing on today, look at the proposed sectoral numerical targets. What happened? Why are we talking about new regulations? In May 2023, a set of regulations were issued to the Employment Equity Act dealing with this issue, which gave rise to significant public comment and concern, and some cases, in fact, where the government was taken to the department was taken to court, and on the doorstep, on the threshold of court, an agreement was reached, and the regulations were referred back for redrafting. One of the concerns that was raised about the regulations was the lack of clarity regarding the implementation of some aspects, importantly, numerical targets in sectors and how one determines which sector and which demographic would apply to you as an employer. So after these concerns were raised, the legislators went back to the drawing board and came up with a new set of regulations, the 2024 regulations, and this is what I'll be looking at today. So this was in an effort to address the concerns in regard to the May 2023 regulations, and basically to clarify which economically active population a designated employer should elect in deciding on its employment equity plan, especially if there are operations in more than one province. It also expands on what constitutes a designated employer. It also expands in greater detail regarding the 5-year targets that you have to build into and aspire to and try and achieve in your employment equity plans. It expands on the way in which the proposed 5-year targets are determined, and more importantly, on how designated employers are defined in the draft regulations and how they should apply the proposed targets. So what's included in these regulations? So the regulations flow from Section 15A of the Employment Equity Act, which provides that the Minister of Employment and Labour may identify economic sectors as and when they deem it necessary, consult with relevant forums, and then proceed to set sectoral numerical targets per sector. In other words, what must you aim for as an employer if you are in a particular sector when it comes to the diversity within your workforce? The list, there are about 18 sectors that have been identified. Some of them are construction, so it applies directly to our audience and their operations, real estate, education, mining, arts, agriculture, forestry, and fishing. It contains information such as the unique dynamics of each sector that is taken into account in deciding what those targets should be. The latest employment equity profiles for each sector. So they went and did some research and found out what is the demographic in that area, in that province, nationally, and in that sector. They looked at aspects such as profiles in regard to race, gender, disability, age, and so forth. So the grounds that are listed in Section 4 of the Employment Equity Act. It also contains information such as a clarification that no person's employment can be terminated by an employer in order to achieve employment equity targets, which is something that was not clear at all from the previous regulations. It clarifies what will happen if an employer justifiably or reasonably cannot achieve its 5-year target. That was not clear in the last regulations, and created the impression of significant fines. There was uncertainty in the 2023 regulations also as to whether the numerical targets were quotas, in other words, you had to achieve it, or whether they were targets to which you would work towards. So let's just drill down into some of those concepts. Designated employer currently is an employer who employs more than 50 employees or has a certain annual turnover, whether or not they have 50 employees. This is clarified in the new regulations. It is now any employer who employs 50 employees or more, regardless of their annual turnover, is subject to the Employment Equity Act and the draft regulations. What that means is if you have fewer than 50 employees, regardless of your annual turnover, you are not subject to these provisions. There are two exceptions, and that is if you're an organ of state or if you are bound to achieve certain targets by way of a collective agreement, either at enterprise level or sectoral level or national level. So that is a fairly large change to the way things are currently dealt with. Then if we look down to the next definition and what is a designated group, and this is one of the major differences that we find with the new regulations. There are now single targets for each sector, rather than separate targets prescribed nationally or per target group. So each sector has its own target. The targets are no longer for specific population groups, but rather apply to designated groups in each sector. So each sector's designated group is then defined as your target. Designated groups are Black Africans, so-called coloreds, and Indians, women of all races, and people with disabilities. So a similarity to the current situation. And then it also provides that in each occupational level where you have to achieve, where you should strive to achieve the target, there is the only differentiation is between male and female. So it's males of the designated group or females of the designated group. It's not broken down any further than that. The next issue is, of course, non-compliance, which is important because a lot of things have to change. The proposed regulations also provide companies cannot achieve their employment equity targets by dismissing people. So under the old regulations, the commentaries that came in and the criticisms were that employers are going to be incentivized to restructure their businesses to remove certain groups to achieve employment equity targets, failing which they would face penalties and fines. So that's been clarified. You may under no circumstances dismiss an employee in order to achieve a target. In addition, employers are provided with defenses in the regulations. I call them defenses, they're probably rather justifications for not being able to achieve your target. And they include if there's insufficient recruitment and promotion opportunities. So if you can't find people from the designated group to promote up and achieve your sectoral targets per job grade, because there's simply nobody to recruit or there aren't promotional opportunities, then that would be regarded as justification. Obviously, it must be very clearly documented. You must be able to prove that. Or if there are insufficient target individuals from designated groups with relevant skills. Or if there are court orders, for instance, that require certain things must be done. So the regulations actually provide that sort of justification for employers. It's not a get out of jail free type of a scenario. There has to be very clear research. You must be able to prove that you have done the necessary recruitment, that you've done the necessary upskilling, that you've searched high and low, and you've been unable to find the appropriate people before you will be able to justify your non-achievement. But it is at least reasonable in that sense. If you have failed to achieve your targets and you have a justification, then the regulations make it clear you face no penalties. And the penalties are significant under the Employment Equity Act. They're based on the same approach as in the competition law, where you can be asked to pay a percentage of annual turnover as a penalty, depending on the nature of offence. And as I said before, no employment termination is permitted as a consequence of affirmative action. So if we look at that, we now apply that to a practical example. So I've taken the liberty of naming this company after myself. I have no interest at all, though, in this business. JVW Insurance has 200 employees. So already we know we're over the 50 threshold. And if we look at the list of economic sectors that I mentioned earlier, the 18 or so, you'll see that the fifth one is financial and insurance activities. So the insurance business falls within the sector that is now part of the list. You'll see construction is number 4, and then the rest are there. So JVW Insurance is a designated employer. What is interesting, though, is that it has 3 offices. One in Johannesburg, and I'm going to pronounce Gauteng, because I said it wrong the last time as a KP. I got it all wrong. Cape Town, and then there's Bloemfontein. And you'll see that the majority of the insurance company's employees are in Johannesburg. Then there are 17 in Bloemfontein and so on. So what can JVW do? They can choose to base their employment equity plan on either the national demographics or provincial demographics, but not both. So they can say, right, we're going to design our plan taking into account which demographics, and the demographics you choose determines your target. So they can choose to look at the national demographic and then plan the economic plan, employment equity plan accordingly, or provincial, but they can't do both. So this demographic, the one they choose, let's say they choose Johannesburg or Gauteng, will be used for the entirety of their employment equity plan. The whole plan for all of the officers must then strive to achieve the demographic of Gauteng. The employment equity plan must then align with the applicable 5-year sectoral numerical target for Gauteng. So again, you've chosen the province, then look at the employment equity a numerical target for the insurance sector in Gauteng based on Gauteng's demographic. So the company may choose, as I said, the economically active profile of either the province or nationally. If they choose the province, they are entitled to choose the province with the majority of their employees, which makes sense in this case to choose then the Johannesburg office. If we then look at the economically active population, sorry, let me just get rid of, is that in the way? Yeah. That is the Gauteng's economically active population broken down into the designated groups. And the plan that they devise must take into account that proportion in determining what their numerical target should be. So we then look at the next stage of the inquiry is to look at the numerical targets for the. Oh no, I've lost one. Not able to move. That is strange. Oh, there we go. You then look at the financial and insurance activities numerical targets for the Gauteng province, which indicates to you that, again, it indicates to you, if you look at top management, for instance, the numerical target for the financial and insurance activities in Gauteng for designated groups at top management level is to have 26% male from designated groups and 20% female from designated groups. Female regardless of race. So that is then the target, if you want, that then forms part of your employment equity plan. And one then must start recruiting accordingly, look for promotional opportunities accordingly, must do your plan in accordance with that. It's a 5-year plan, submit it, and then work towards that. As I said earlier, to the extent that there are limited skilled persons, that would be a justification. If there aren't promotional opportunities, that would be a justification. The regulations signify a significant change in the approach in this sector of the law. They will place significant obligations on employers. You will be scrutinized very carefully to decide whether you are taking the necessary steps to achieve your goals. And one has to be very careful in one's planning, deciding on whether it's national demographic or provincial, and in order to achieve your goals. And that's all from me. Thank you very much. Are there any questions? Thank you. Thank you. Thank you so much.
Jenny? No. The little bit of license to seeing Jacques is really an employment lawyer here. One quick question.
Sure.
I know other people, sorry.
That one.
Jacques?
Yes.
Jacques?
Mark failure.
Speak loudly.
I'll talk loudly.
Yeah.
Jacques, very quickly, some of the standard form construction contracts have got a provision in it which says that an employer can require a contractor to remove one of the contractor's employees from site.
Sure.
If for various reasons that's detrimental.
Sure.
Does that not fall foul of that employee's rights in terms of the Constitution for a fair labour practice? And I'm thinking of FIDIC here in particular.
So the contractor would be some contracts contain a provision which allows the client to ask a contractor to remove an employee, or I guess employees, from site. I don't know if there has to be cause, or is it just a contractual right?
If it's detrimental for reasons. Yeah.
And the question is, does that infringe on the employee concerns right to fair labor practice? So those are, I assume, temporary employment services. Those companies are contractors, or they just, or
No,
they're not.
Permanent employees of
right.
the contract.
So they're employed by the contractor. The contractor cannot, on the say-so of the client, terminate the employment of that employee. There has to be cause, one of the grounds permitted by the Labour Relations Act for dismissal. So to the extent that there isn't cause, and the employee is prejudiced in any way, so loses employment, is retrenched as a consequence of that decision, they would have their rights in law to sue the contractor, as I understand.
It doesn't go as far as to terminate
Oh, yeah.
employment, just to remove from site
Yes.
if they're dangerous.
Yes. As long as the employment isn't jeopardized in some way, so there's no unfair labor practice concern or unfair dismissal, they would have no right to complain about that.
Thank you, sir.
Yeah.
There are sort of, if you like, competing contracts here, because there's the contract between the employer and the contractor on the one hand, and then the contractor and its employee on the other hand. Now, the contractor must honor the obligations under the contract to the employer. And if the contract says, if anything like this happens, then I want one of your, whichever employer's lead is responsible for the infraction consent to leave, that's within the prerogatives under that contractual regime. But that, as Jacques points out, doesn't give rise to a right to terminate the employment relationship. On the other hand, they must make other arrangements somewhere else.
Yes. Yes.
Thank you.
Okay.
Thanks.
Any other questions? Yes. Top management, yes. No.
Okay, the online audience cannot hear those questions. If you can repeat them, please, before answering.
Sure. The question is the numerical target for women in top management in the example that I presented was 20%. Is there another requirement within that there be targets for on the basis of race? The answer is no, because women are a designated group, regardless of race, is the answer. Third and last opportunity. Thank you, I think. Okay, okay.
I hope the online audience can hear me.
I'll repeat it.
Okay. My question is, just thinking, I mean, the regulations are published. Do you have any sense of the timing of the implementation of the regulations at this stage? Understanding, of course, you can't give a definitive answer. And secondly, how ready must parties be to roll out the implementation? And thirdly, sorry, three questions in one. How will they be policed? Practically.
Okay, so the first question is, when will the regulations come into force? There's no indication whatsoever.
Could be tomorrow, could be a year.
Could be. With the transition to the government of national unity, that might also be a factor. The bottom line is that the regulations are a result of interaction between interested groups and stakeholders and government. So a far better buy-in into the new regulations than the first set, or the 2023 set. So that's not a hold-up. There's no pending litigation in that regard. The second question was, oh, there will be a transition period. There will be a transition period, but you'll have to quite quickly, in developing your next employment equity plan. So plans expire, they have a time limit. You're going to have to incorporate these regulations when they're in force into your thinking, and what your targets are going to be, and so on, and whether you're going to use provincial demographic or national demographic. The Department of Labour polices it. you have to submit your plans, and then you have to submit an update report annually, and they will police. They will look at your plan. They will look at the history of your plans. And one of the offences is that you've made no material progress towards your own targets, and that attracts a significant percentage of turnover type of penalty. So it is important to take them very seriously.
Can I ask one more question?
Of course, yes.
Very interested in this. So Jacques, if in your experience, because I understand that the first set of regulations got jettisoned and now we've got this new lot, so we actually haven't seen these in action. Have you had any interactions that tend to indicate how ready the government is to actually monitor, assess, and police these plans?
So certainly amongst my clients, there have been no penalties. There is a shortage of staff from an enforcement point of view at the Department of Employment and Labour. Every now and then there's a notice that comes out from the ministry that there's going to be a blitz. So you better be ready, and we're going to be strict. But it's not been enforced as much as one would hope. That's all I can say. Thank you very much. Sorry. Oh, yes. Is that in relation to the first question, I suppose? So just repeat the, would it be? Well, I assume, and Jenny might be better at answering this question. In those agreements, there are contractual obligations, which can be enforced. The rights of employees arise from the law, the Labour Relations Act. No doubt there will be a contract of employment as well with that person, or hopefully, which may also create contractual obligations. And in employment law, you do have two avenues. One is you can claim that your dismissal was unlawful because it breached the contract of employment, and you can go to the High Court in a purely contractual scenario, or you can allege that the termination of your employment was unfair, in which case you proceed under the Labour Relations Act to the Bargaining Council or the CCMA, and then to the Labour Court from there. Yeah. Good. Thank you very much. Thank you.
Thank you so much, Jacques. I think it is important for everyone to be alive to these developments in this space, because it will impact on every medium size and up business within the construction sector, as we've seen. Just to confirm and reiterate, I don't think from a sort of a FIDIC or NEC type scenario, you won't ever see employers having a right to interfere in the contractual employment relationships between the contractor and their employees, on the other hand. All right. So that was Jacques, who is in our employment department, but also part of the construction and engineering practice group, giving advice to a number of our construction and engineering clients at Werksman's. And I think if there's ever a query or an issue arising in the context of trying to comply with or follow these regulations, I think you know where to go. Next up, we have Natalie Scott, a director in our ESG and commercial side within the firm, and she'll be talking alongside Salome. I'm sorry, what? Okay. My apologies, I had the order of the speaker lineup incorrect. We're starting with Salome Rankapole, who is an associate in my team in the litigation department within the construction engineering practice group here at Werksman's. They are going to be talking to the recently enacted Climate Change Act, which was passed by the National Assembly in October last year and promulgated and signed into law in July 2024. It is therefore now in play, and there are some very important considerations that every business, but also the construction sector in particular, because it is one of the bigger emitters, must pay attention to and be aware of. So I'll leave it to their capable oratory skills to convey it. Thanks, Salome.
Hi, everyone. So I'll be jumping straight into the genesis of the Climate Change Act, and then I'll be speaking to some of the important provisions that people within the construction engineering sector need to look into. And then Natalie will be focused more on the ESG side of things as well as the reporting. So yeah, so in around December 2015, 196 parties adopted the Paris Agreement. And then on the 4th of November 2016, the Paris Agreement became a legally binding treaty. And the main objectives of the Paris Agreement are the first one is to halt the increase in the global average. Sorry, guys, I wasn't projecting the slides. So the main objectives of the Paris Agreement are to, amongst others, one, hold the increase in the global temperature to well below 2 degrees Celsius above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees Celsius above pre-industrial levels. Second objective is to increase the ability to adapt to the adverse impact of climate change and foster climate resilience and low greenhouse gas emissions development in a manner that does not threaten food productions. The signatories to the Paris Agreement were to prepare and communicate nationally determined contributions, which they intended to achieve in accordance with their response to climate change, as well as to align with the objectives of the Paris Agreement. So South Africa is one of the signatories, submitted their first nationally determined contribution in September 2021. But despite the fact that they only submitted in 2021, it must be noted that they have made efforts and shown their commitment to curb the rise of climate change by, amongst others, promulgating the National Environment Management Act, which was subsequently followed by the gazetting of various regulations to guide the emission of greenhouse gases. We also have the Carbon Tax Act, which was promulgated in 2019, which also deals with reporting as it relates to greenhouse gas emissions. Now, from 2018, the National Council of Provinces, as well as the National Assemblies, had various engagements with regards to the climate change bill. And then it was formally introduced to Parliament in around November 2022, whereafter it was adopted by the National Council of Provinces in April of this year. And then in July, the president signed it into law. So over the years, the United Nations has also come up with 17 sustainable development goals. Goal 13 relates to climate change. These goals aim to address, amongst others, climate change and are in some way or another all interrelated. The United Nations aims to achieve these goals by at least 2030. This seems to be a little bit of a stretch, seeing that we are drastically off track, but there's absolutely no harm in trying to reach these goals by 2030. So, as I've already mentioned, climate change is sustainable goal number 13 and has 5 main targets. I'll only be listing 3, which are to strengthen resilience and adaptive capacity to climate change disasters, integrating climate change measures into national policies, strategies, and planning, building knowledge and capacity to meet climate change by improving the education of climate change and raising awareness on how to best mitigate the effects of climate change. So before I move on to some of the most important provisions of the Climate Change Act, it's important to give a brief background on how the construction and engineering industry actually contributes to the emission of greenhouse gases and global warming in general. So South Africa has a very intense carbon and energy infrastructure. It's really unsurprising as the materials used in the construction industry are high in carbon. Take, for example, bricks, cement, steel, and other manufactured components which are extremely high in carbon. In addition to this, South Africa's economy and power generation system is mainly reliant on production and sale of coals. Naturally, the manufacturing and construction industry relies on material which is generated through coal-powered production or generation system. Coal and carbon are high emitters of greenhouse gases, which contribute directly to the Earth's temperature. The construction sector contributes approximately 37% of global greenhouse gases, and it is therefore essential that if South Africa is going to make any meaningful contribution to the mitigation of these greenhouse gases, it must first consider the mitigation of greenhouse gases in these sectors, which includes obviously the construction and engineering sector. I'm now going to go through some of the most important provisions of the Climate Change Act, which have a direct impact on people within the construction and engineering sector. The first one is sectoral emissions. In about July 2025, which will be a year since the Climate Change Act was enacted, we expect the minister to list the greenhouse gas emitting sectors and subsectors, which will be subject to sectoral emission targets, and which reflect the national greenhouse gas profiles. These sectoral emission targets will be reviewed every 5 years, and if necessary, the targets will be revised or amended. The minister responsible for each sector, in terms of which sectoral emissions have been determined, must, within a year of the publication of the sectoral emissions, implement or develop policies and measures for which the minister is responsible, plus publish amendments in the Government Gazette and implement same, as well as to monitor the effectiveness of these policies once they put into place. The minister will also publish a list of greenhouse gases which he reasonably believes cause or are likely to exacerbate climate change. The minerals or the greenhouse gases list has not yet been published, but if you look at the Carbon Tax Act, it should be able to guide you on what these greenhouse gases are and which sectors will probably be subjected to subjected to these greenhouse gas targets. And the construction industry is one of those. It's already listed in the Carbon Tax Act. So it's expected that when the minister publishes these regulations, the construction industry is one of the industries that will be affected. Now, the most important of these provisions is that the minister must allocate carbon budget to all persons who conduct activities which emit greenhouse gases. In allocating these budgets, the minister will, amongst others, take into account the socio-economic impacts of imposing the carbon budgets, the best practical environmental options available, and alternatives that could be taken to mitigate the emission of greenhouse gases. The allocated budget will have a duration of five consecutive 3-year periods, and will specify the maximum amount of greenhouse gas emissions that may be emitted during the first 5-year period. If a person has been allocated a carbon budget, the person must prepare and submit to the minister a mitigation plan. This plan will set out and describe what plans the person who's been allocated a carbon budget intends to take in order to limit the emissions of greenhouse gases in terms of his allocated budget. If a person has been allocated a budget, he must implement the greenhouse gas mitigation plan. Obviously, before the implementation must have been approved by the minister. Person must monitor the implementation of the mitigation plan, evaluate the progress on the allocated budget, as well as report on the progress against the allocated carbon budget. Where it appears in the reporting that the person has failed, is failing or will fail, then they must come up with another mitigation plan which sets out how they intend to remain within the actual allocated budget. I don't actually think that the legislature thought this one through, because how do you mitigate something that you've already exceeded? So it then remains to be seen how this section of the Act will be implemented. The carbon budget allocation is not set in stone. So if you've been allocated a carbon budget, you can apply to the minister for a revision of the budget or a cancellation of the budget. The minister will publish the regulations which list the circumstances under which each person can then apply for the revision or the cancellation. At this point, it remains to be seen what these special circumstances will be. And it goes without saying that if you don't comply with the provisions of the Act, you will be liable to a penalty. Natalie will speak more on the penalties, which persons who don't comply with the Act will be subjected to. So, Climate Change Act is linked to various other acts. So you can see South Africa has been doing quite a lot in this regard. We have the National Environmental Management Act, which is one of the acts which was implemented in response to our signature to the Paris Agreement. We have the Hazardous Substances Act, which provides for the control of substances that emit greenhouse gases. Carbon Tax Act, which I've already mentioned, also regulates the emission of certain greenhouse gases. I'll stick to those for now. So everyone has a role to play in the limitation of climate change, or the curbing of climate change, rather. Following what transpired this past weekend in the Midlands, I think everyone saw what happened. People were snowed in. I have certainly never seen this happen in South Africa, uncharacteristic of South African weather, but it also highlights that global warming is real and that everyone has a role in developing a climate resilient South Africa. That being said, there are many ways in which we can play a role in limiting the emission of greenhouse gases. One of those is sustainable housing. So sustainable housing means, in a nutshell, housing or building a house or home that is environmentally friendly, socially and economically stable from the initial design phase right through to the construction and living phase. And one of the ways in which you can practically ascertain whether or not your house is environmentally friendly is looking at some of these factors. The first one is the size and the type of the house. there's a movement which they call the tiny home movement, which prides itself on having a lower impact on the environment by reducing the carbon footprint of homeowners. Another one is the shape and geographical orientation of your house. So when building, maybe just consider how or where your house is facing, because, for example, a house situated in the southern hemisphere will be more energy efficient from a heating perspective than a north-facing house, so vice versa. Then you must also consider the material and construction methods that you use in building your house. An example of this would be using less carbon-intensive materials, such as bamboo, and maybe think about recycling your wood and your steel. It is also worth considering energy-friendly power sources such as solar energy to reduce reliance on coal-related or coal-generated electricity. Natalie will now be moving over to the reporting regulation. Thank you.
Okay, so I'll have a look at the reporting obligations in relation to the Climate Change Act. I think as South Africans, we are all exhausted in relation to the various reporting requirements that we have under all of the acts. There is already a lot that we have to do under the guise of environmental legislation, and there doesn't seem to be any form of cohesion in relation to those or consolidation in terms of those regulations. So what we anticipate will happen here is that the Climate Change Act, with the regulations that are published underneath it, will actually bring all of these requirements together, or that to the extent that you have reported on certain other environmental laws or certain other specified laws, that will suffice for reporting under the Climate Change Act. But I think, as we've seen in Europe and in the UK, because clearly that's no longer part of Europe, and the USA, what we're seeing is that they are actually starting to consolidate the frameworks, which are the measurements for determining your carbon footprint, the sustainability of your business. So we have seen a lot of changes in the last couple of months because we had a proliferation of different frameworks and measurements. None of them spoke to each other. And what we're seeing now is them actually trying to integrate that. And I think that that is what we're going to start seeing in South Africa. So just going back to a point that Salome mentioned a bit earlier, is that you're going to have different sectoral targets and budgets that will be issued to you. And the way that they will be ostensibly determined will be from COP. It will be by the United Nations, and that's one of the many reasons that we've had so much squabbling at all of these ESG events and world organization events, is because each country has been allocated a specific target currently, and those targets will obviously change over time. And what happens typically is it's the top-down approach. Whatever the South African or the state of South Africa is given in terms of its targets, those targets will then be pushed down. They get pushed down to provincial level, and they get pushed down to municipal level, and they get pushed down to a sectoral level. And obviously the big carbon emitting industries such as mining, construction and engineering, manufacturing, those are going to be targeted first. So what we are envisaging will happen is that they will have a sectoral target, and then they will divide those targets into the biggest emitters, or who they anticipate are the biggest emitters. And then your plans, your carbon budgets and your mitigation, your greenhouse gas mitigation plans will have to be built around that. And I think we'll see some movement from time to time. As Salome mentioned, they endure for a period of 5 years. And you can adjust them during the time, allegedly, but we don't know the basis for the adjustment and when the adjustment will come into effect. Under South African legislation, I think the Climate Change Act is pretty thin. It's very detailed, but the implementation aspects of it are thin. So we are expecting that to come through in the regulations. Okay. Oh, the other thing that I just wanted to mention in terms of the reporting requirements is that IFRS has come up with a standard 1 and a standard 2. Those standards actually already assist companies to the extent that you are applying them or that you will apply them in determining your sustainability impact, not only in relation to your particular business, but the business that you will be doing with third parties. So those will already start coming into force if you use IFRS or the South African GAAP and pegged to IFRS. Those will already start coming through from a financing perspective, and those can be used to facilitate the various budgets and reporting requirements that you will be allocated and that you will be required to produce in South Africa. The fun part, this is always nice to scare everybody. So they've been very generous in the Act, and they've split them into sort of first and second offences. So if, for example, you don't comply with any material provision of the Act, they've yet to determine what the specifics in relation to materiality are. If you don't comply with your carbon budget, if you don't submit your greenhouse gas mitigation plan, first offence, 5 million rand or imprisonment for 5 years. Second offence, 10 million rand and or imprisonment for 10 years. Okay, this also then feeds back into directors' liability at company level. We already know that directors can't exclude liability at company level for any environmental issues, environmental impacts, and that's exactly what this is going to play on. So one of the other ways that companies can start having a look at mitigating factors and the processes and the policies that they have in place is to have a look at King 4. We see that a lot of companies are volunteering to adhere to King 4. Those do give a very good indication as to the controls that the company has in place. And I would recommend that companies start putting some money aside for consultants that can assist in measuring your carbon footprint, that can give you goals, that can confirm that the carbon budget that's been allocated to you is appropriate, and to help you measure that. Because the biggest problem that we have on or in sustainability or in ESG is that we have a lot of data. We don't necessarily know where it is, and we aren't necessarily capturing it correctly. So just as a step aside, on our sustainability journey, there are a lot of things that Werksman does right, except we're not publicizing it. We're not saying anything because things get done in pockets. So this is intended to be slightly more cohesive legislation to bring everything under one umbrella, but whether it achieves that or not is yet to be determined. Okay, so statutory compliance I've already mentioned. The supply chain issue is huge for climate change. You have to start measuring the carbon footprint and the sustainability levels of your suppliers, and you will see those frameworks and the requirements being pushed down on you as well. We have seen a lot coming from our clients in terms of sustainability policies, our carbon footprint, and that is literally just to pitch. That is not just about getting the work and continuing existing work. So if you haven't already seen that, those are going to be the types of things that you can see, because the carbon footprint is a chain. So you don't want to be doing business with, or let's say you would prefer not to be doing business with, someone who has a carbon intense footprint, as opposed to dealing with somebody that doesn't. I think what we can also see coming in the future is the trading of carbon credits, whether or not if you are below your targets or below your budget, whether you will be allowed to sell the difference to somebody who's over there, so that there's a balancing act. Whether we are allowed to do that, we will see, but it's certainly being planned. And a couple of years ago, the JSE did actually open up a carbon segment, but the bottom fell out of the carbon market at the time, and so it didn't proceed. But there are already mechanisms in place. You'll see there are different segments already on the JSE for listed companies. Those will also give you a very good indication as to the requirements that the regulators are going to be imposing. SIPSE's already issued its notice that came through from the Prudential Authority to say that SOEs and listed companies are going to have to start reporting on their sustainability achievements and targets, one of which is climate change. So we do know that it's coming. The form and shape is yet to be determined, but we do have an outline. And then just the building plans. So a lot of the building plans, we see it as well in Europe, that, you know, to the extent that your building plans contain sort of building with more sustainable material, that if you're using Semcrete or some other form of concrete as opposed to the concrete in the form that we've traditionally known it, those plans will be approved faster than the plans that are less environmentally friendly. They're likely to start asking for more information about implementation of those plans, for details of the consultants, who's going to be involved, because all of that will drive your carbon footprint, your sustainability strategies, your climate change mitigation, and your greenhouse gas emissions. Thank you. Thanks, everyone. Are there any questions?
We have one question. I started checking the room if there's anyone first. I was just curious on this budget question, if I may. So you say that the budget is allocated for a 5-year period. So I don't know how many tons of carbon you're allowed to now burn.
Yeah.
If you've got to try and develop technology to try and catch up, if you're trying to with the obligation to mitigate, presume in year 1 you can use up more of your budget than in year 2.
Yes.
That can be your plan. So you can say, I'm on a downhill trajectory, but I'll use up my budget over that 5-year period. So that's the idea in terms of budgeting.
That's the idea. How it actually manifests itself and how it comes out in the regulations will be interesting. South Africa is measured on a 5-year period, and so whether they will impose, so like you have to have achieved X by year 1 or 2 or 3, and you can't set it off across the different years and one year be worse than the next year because you're automatically correcting. That remains to be seen, but as currently drafted, it looks like it's going to be sort of like a rolling 5-year period where you can achieve, you know, more in one year and less in another. But don't forget there that you do still have the deliciousness of the financials that you have to produce, which will set all of this out.
Then the other thing I was just thinking, as you were talking about supply chain and all, because it kind of ties into what sectoral requirements that JARC has in a way. It's trying to change people's behaviors
Exactly
to address issues. This is an environmental issue. So I presume what you're envisaging is coming through is likely that in a sectoral determination, certainly certain companies which are larger, let's just say that smaller companies, will have those reporting obligations, but they will then in turn choose suppliers who are more sustainable. So everyone is part of it. It's almost like an ecology of.
That's exactly right. That's exactly right. That's why the supply chain becomes so important.
So it takes everyone from the small guys right to the biggest guys.
Yeah.
So it is very important for everyone to take notice of these, because it will affect their ability to procure work going forward.
100%. And the other thing to bear in mind is that it will not only affect your competitiveness, but it will actually affect your viability as a business, because if your carbon emissions are heavy, you've committed to a carbon emission reduction, you cannot afford to have anybody in your supply chain who is going to contribute to that. So they split out the greenhouse gas emissions into the scope 1, 2, and 3, and they deal with these are certain emissions, or you would be emitting these types or this type of carbon, or this percentage of carbon over a period of time based on what it is that you do. So that is your locus of control. And then those areas where it is you do not have control over these particular aspects, and that's where your supply chain comes in. because the test for your own carbon, emissions and your own carbon footprint is pretty easy and pretty clear. It's the additional carbon that goes into your footprint as a consequence of the third parties that you deal with that could potentially blow you out the water.
And we'll be a power of choice. No, thanks.
Yeah, pick us.
I just got one more. I just got one more question here from the chat group, which let me just read it. How are contractual obligations and regulations in South Africa evolving to promote climate resilience and environmental sustainability in construction? And are there incentives to encourage contractors to exceed basic compliance standards? Feel free to answer. I've also got
Can you do that at the next seminar? Because that's an entire presentation. So, there's always the obligation to comply with statute. You can't contract out of it, despite some people's view and the desire. It is what it is. What's happened is that we have assumed traditionally that everybody is complying with the law, and we make them give reps and warranties that they apply with all applicable laws, whether it's to the extent that it is material to their business or to the extent that it doesn't have a material adverse effect on you as the counterparty. I think what we're going to see now are very specific requirements. I mean, we've seen it in our due diligence that we are, our questionnaire that we are currently in the process of beefing up. It's no longer just good enough to get a blanket statement. So you actually then have to make sure. So certificates, your ISO certificates, your movement towards your sustainability, the sustainable development goals, meeting those particular criteria. And again, the publication side of it is very important, because it means nothing unless you have the credential and you can publicize it. And I think there's generally a reluctance in the South African market, either because people don't know, but if they do know, they're not sure. And if you publish it and it's wrong, you get into trouble. So I think it's a bit of a balancing act, but I think we will see more very specific clauses coming through. There are specific provisions that we have to make sure that there is compliance with climate change. You can publish a climate change statement. You can publish a statement that talks to, that you've adopted the various principles of the Paris Agreement. So those are the kinds of things that you can do, and they might very well start forming part of sort of counterparty engagements. They will form part of financing arrangements. They will definitely have an impact on the margin that you can receive, the nature of the covenants that will govern your particular agreements. So we are seeing a huge push from the bank side. So they also want to see your reports. They want to see everything. And that is also another thing just to bear in mind, that if you lie on any of the reports that you submit, inadvertently or otherwise, on the reports that you submit to the regulator, to the minister under the Climate Change Act, that will be verified against the information that you've given to other parties. And you could go to jail. Jenny, do you want to add your part?
I think you've answered the question.
Okay, great.
I'm not going to step up again. Thank you, Natalie.
Thank you. Thanks, everyone.
Oh, sorry, I beg your pardon. There's one more question.
Gosh, sorry.
Where?
Back again.
And you feeling it's yeah. Okay. Just wait, it's coming.
Okay.
When you reply, it's not coming through the or you can just bring it to me and I can read it. Or you can read it.
How will one measure the compliance of contractors with construction sites around the country?
How will one measure the compliance?
How will one measure compliance? Okay, so there are a number of ways. You can ask for the delivery of the various reports, confirmations. We've seen sworn statements, affidavits, those kinds of that kind of information and those sorts of requirements. We've seen that coming through. There may very well be a database. There has been chat about it where people's compliance certificates, sort of a national database where compliance certificates, your plans, your footprint, etc., all that information will be available. There's nothing stopping you, though, to ask for all of that information. And I think just to be practical about it, you know, if you get representations and warranties and undertakings and you ask for certain information and they give you that information, there is nothing more really that you can do other than asking for the information. There's no responsibility on you to now go and verify that that is 100% correct. If you want proper verification such that you can rely on it, you need to get an insurance certificate from the counterparty. That would then be provided by a third party. It's expensive to give. And we don't anticipate that anyone other than the big corporates will be able to provide that. But hopefully over time, with economies of scale, hopefully those certificates will be less expensive. But again, in terms of the sustainability reports, you will be able to rely on the information unless it's flagrantly incorrect. But those are the types of things that you can ask for. But yeah, verification, assurance, confirmation from auditors, accountants, third-party agency, the verification agencies, the assurance agencies, they are issuing those types of certificates.
Yeah, at one level, the measurement of what is emission, what is an emission, and what is as against your budget is a scientific exercise. Somebody has to come and see what you're doing. Some of that relates to materials used on site by contractors. So yeah, if you, for example, say, I'm going to use a certain green product and then you don't, well, that's obviously a misrepresentation in your contractual provisions. There's consequences. That's how you hold it to apply to accounts. That would be one way. But I mean, I wouldn't imagine there'd be. I imagine there might be some inspectorate coming along. I don't know. Yeah, but the regulations will inform all of that in terms of what to expect in that regard. I think that answers the question. Okay. Okay. We'll close our Q&A.
Okay. Thanks, everyone.
Thank you very much. That's beautiful. Thanks. And then next up, we have our third and last, but no means least, fantastic speaker of the day. His name is Dewald. He's a partner at Werksman in our litigation department, also in construction and engineering space. And he's just going to talk to us about a very important thing to put in your brain somewhere, park it carefully, and not forget. Because when it comes to, if you have a claim and it prescribes, it's gone forever. So this is just a general strategic line of advice, I suppose, or just a general view that we'll share with you that will thinking how to manage claims when they and as they arise. I hope. Anyway.
Thank you, Jennifer. Can somebody just assist me on how do I work these slides? Because if I start pushing buttons, we're going to have an issue.
We'll just simple. So we just.
Oh, there we go. Okay, lovely. Thanks so much. I presume that I'm looking at the camera with everyone online and the other side. Good evening, everyone, and everyone in the room. A little bit of this presentation makes me feel like I'm back at my wedding speech, but let's just kick off. I think prescription is a particular area in our law that I would say regularly gets ignored or not taken as serious as it should be. It has major ramifications on any front, arising whether it's from contract or otherwise, and in particular, your ability to enforce a debt that is due. People don't always take the time to put the necessary measures in place to ensure that the claims don't prescribe. And before I delve into the various discussion points, I've been at the giving end of having claims of nearly 400 million rand kicked out on prescription. And I've been on the receiving end of clients having substantial claims kicked out on prescription. So it is something to be taken serious. So I'm going to obviously really deal with it on surface level. And if there are any particular queries you may have, as Jennifer said, please feel free to reach out to us. The 4 discussion points are, as per the slide, it's obviously the concept, the periods. I'm only going to deal with the one period, and when I get to, I'll explain why. And then obviously, when does prescription begins to run, which is a fundamental feature.
and under what circumstances is the running of prescription interrupted, and obviously a few practical considerations. As a starting point, what the law seeks to achieve in the principle or legal principle of prescription is you need certainty. You can't have a scenario where everyone can at any time simply so-called pursue a claim that they want to persist. And I'm going slightly off screen because there's something on my left that I'd like to just read to you, which doesn't form part of the slide, but it was just so aptly put by a judge in a matter. So you must just give me 2 seconds so I can just find the page in my file here on the left. For me, it's the quintessential explanation where the court said, in dealing with the whole principle behind certainty is, and this is the relevance. The court said the main practical purpose is to promote certainty in ordinary affairs of people. And it says the alleged debtor may have come to assume that no claim would be made, witnesses may have died, memories would have faded, and documents or receipts may have been lost. It's a fact that we so easily ignore, but I've had so many clients sitting in that scenario and say, but this guy doesn't work for me anymore, or he's retired, or he lives somewhere else. There's no one you can talk to. So it's one of those aspects that I think the law simply says we need to create certainty, and in doing so, we implement a number of principles. So the various periods of prescription range from 30, 15 to 6 years, and the relevant one that so much features is the 3-year prescription period in respect of any debt. So I'm not going to deal with any of the remaining periods, but the Prescription Act says in section 12 that prescription begins to run as soon as the debt is due. Now, obviously, in pursuing that debt is certain necessary aspects need to be present. And the Act provides in section 12.3 that a debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arise. Now, you only need to read the various cases dealing with prescription to realize the kind of arguments that people on both sides of the divide can make as to whether or not the facts are present. So, and the relevance of that statement is that there's no specific, these facts are relevant, those facts are not. The legal precedents that have been expressed on this area have simply sought to create a certain level of certainty. And I think where, for me, is quite a nice explanation is everyone would be familiar with the McCarthy versus Vodacom matter. That's the please call me matter. And there, Justice Wallace said, the correlative of a debt in this sense is a right of action vested in the creditor in which the payment of money or the delivery of goods or the rendering of services is claimed. Debts become due when they are immediately claimable or recoverable. Now, in that particular instance, they dealt with an obligation to negotiate in good faith. So the court just made it very clear that these are the type of claims that will form the subject matter of a debt that can be the subject of prescription. Now, knowledge of identity of the debtor, it's pretty straightforward, but the relevant component or requirement that gets a lot of attention is the so-called requirement of the facts, the minimum facts. And there's been various cases that has dealt with it, and in the matter of Minister of Finance versus Gore, and I'm pretty much going to just paraphrase what's on the slide, but it's important that I do so. The court said, this court has in a series of decisions emphasized that time begins to run against creditor when the minimum facts that are necessary to institute the action. The running of prescription is not postponed until a creditor becomes aware of the full extent of its legal rights, nor until the creditor has evidence that would enable it to prove a case comfortably. So there's almost this perception that I can't pursue my case until I've gone to see my lawyer who tells me that I've got a claim. That's not the test. That's not your minimum facts is not dependent on someone else confirming to you that there's sufficient evidence or that you will, as we would say, win your case. So that cannot be the test to apply in whether or not the minimum facts are present. A perfect example is the next matter, Truter versus Daisel. And in this particular matter, the gentleman underwent an eye operation, and obviously something went wrong. And he went and he saw various specialists, and all the specialists formed the opinion that nothing was wrong. I mean, that the doctor who performed the operation did nothing wrong. Until he eventually, I think the fifth expert that he went to see years later, then came to the conclusion that there was negligence. And the court said in that particular instance that a debt is due when the creditor acquires a complete cause of action for the recovery of the debt, when the entire set of facts which the creditor must prove in order to proceed with his or her claim against the debtor is in place. In other words, when everything has happened which would entitle the creditor to institute action to pursue his claim. And the court said in that particular instance, you can't wait for this expert, external expert now come and tell you that you have a plausible claim. So do not wait until you get to that stage to determine whether or not you need to pursue your claim. Because what has happened in this particular instance, the event of the operation has taken place, the hurt of the eye has taken place, the initial medical checkup has happened. So all the necessary facts were present to pursue the claim. You don't need to be in a situation where you have each and every aspect of the evidence necessary to successfully pursue the claim. So just a little bit more of the same. Group 5 Construction, Minister of Water Affairs, it really just says the debt is recoverable, owing, and already payable or immediately claimable when the creditor acquires complete cause of action for its recovery. And lastly, Mackenzie, which is an old case, which simply just says at the end, it does not comprise every piece of evidence which is necessary to prove each fact, but every fact which is necessary to be proved. As a side issue, whenever we prepare pleadings to pursue a claim, we are obliged to plead the facts which are necessary to prove the claim. We don't plead the evidence. So it's very important that you don't sit and wait until you eventually get to that point where somebody says to you, now you do have a claim, and only do it at that stage. And I think just the final one on that scenario, where the court in the matter said it related to somebody where money was unlawfully taken out of their bank account, and they waited until they got the identity of the person who received the money in their account. And the court said that was not necessary. And unfortunately, it took them over a 3-year period, and the court held that claim prescribed. So prescription is unfortunately a little bit uncertain. So ultimately, the moment you get to that point that you are of the view that you have a claim, I think take the necessary advice as soon as possible. Now, prescription gets interrupted in a number of instances, and the objective behind the interruption is to bring us back to certainty, because that's ultimately what the law seeks to achieve in relation to this. Now, prescription gets interrupted in a number of ways. It can either be through the express acknowledgement in writing, because the moment the person acknowledges, yes, I do still owe you the debt or the indebtedness, then there's certainty and there's no reason for the law to take a different course. And obviously, the other manner in which prescription is interrupted is by the institution of process. And that is obviously defined in terms of Section 15 of the Act, and it includes a petition and notice of motion, Rule 9. I'm not going to bore you with the pleading relevances of that, but in main terms, you would need to go to an attorney, you would need to start the process, and obviously as soon as possible. Now, what's very important and why I included it as point number 3 in the matter of Group 5 construction of as Minister of Water Affairs, in that particular case, which very complicated contractual arrangement, one of the steps in the dispute resolution process was a notice to be given by the engineer to say that the parties have now kind of reached a stalemate and either party can now proceed to court. And in this particular instance, the party failed for some time to do so. And obviously, when the opposing party took a prescription point, they said, but this notice that was sent constitutes an interruption of prescription. And the court just said it's not. The definition of process is very clear, and it does not include that. So please do not rely on some written notice external that you say, now I'm going to pursue this claim against you, and if you don't pay, and then believe that you've now interrupted prescription, because that doesn't constitute process. And just on a further point, and this is obviously I'd love to talk in detail about Section 13, but I'm only going to really focus on 13(1)(f). Section 13 deals with essentially the suspension of the prescription period in the event that certain events take place. In the particular instance that we're dealing with now, which is obviously relating to arbitration, and I just want to read from the Act for you. It says that if the debt is the object of a dispute subjected to arbitration, the relevant period of prescription would, but for the provisions of this subsection, be completed before, on, or within 1 year after the day on which the relevant impediment referred to has ceased to exist. The period of prescription shall not be completed before a year has elapsed after the day referred to in paragraph I. So effectively, a year after this arbitration is now completed, you must ensure that you follow the Prescription Act in pursuing your claim. So all that the arbitration does is it effectively does the pause button. So it's very important that you are familiar with Section 13, and that you don't think you're in the world of, I've got another 3 years where I can rest and wait to do something. So just finally on that score, and slightly off point, but in point 5, Murray and Roberts Construction was Uppington Municipality. Effectively, it dealt with a provision and an agreement that had, as we know, your standard 3-stage dispute resolution process. First, referring to the engineer for his determination, which in this case was final and binding, and then they had a mediator scenario, and if that failed, then they go to arbitration. And essentially, the court in this particular case found that the reference in Section 13 to refer to arbitration includes the first stage of referral to the engineer. And it does not include only the last part of the dispute resolution referral to the arbitration. So it's very important that you're familiar with that. And just finally, once your arbitration is completed and you have an award in your favor, you have 3 years to make application to the High Court to make the award an order of court. Your arbitration award also prescribes after 3 years. Do not think because I've now got an award that I've got a court order. So, and people unfortunately make that mistake, but please be alive to that. And there's finally some practical considerations. You can't get condemnation. So if you miss it with a day, you've missed it. You can't write to the judge and say, I had a family issue. Its prescription is literally, I would say, that one thing that keeps litigation lawyers awake at night. So please don't think you can overcome that. A letter of command does not interrupt prescription. So please don't come to the lawyer and say, yeah, but I send them a letter of demand forcing my claim. It doesn't suffice. And thirdly, a liquidation application does not interrupt prescription, because then a liquidation application does not constitute a process by which you claim payment of a debt. So please don't think that that's sufficient. An important, precise knowledge of the quantum of a claim is not required. As a side issue, if there's a scenario where a certain design, let's say there was a particular facility that the client required to be designed, and pursuant to the design contract, it's found that there's certain breaches in relation to the requirements under the agreement. You can't expect to find definitive external advice that there is indeed been a breach before you can pursue the claim. So it's quite important that you don't get focused on that preciseness before you pursue the claim. And lastly, I mean, it will always remain up in the air. It will always remain slightly nuanced. So the moment there's a claim, you're aware of the claim. Obviously, please reach out to your attorneys. If it's us, then love to help you. But it may be a good starting point that, and to just take one step back, an interim payment certificate as an example, depends obviously on what the agreement is, but generally that's immediately claimable and payable. So you can't wait till the end of your contract until the project is completed to now only claim pursuant to that interim payment certificate. So if you have a contract intensive process, create an internal, I call it prescription system, where you flag the month period when that is and where your 3-year period is, so that you don't lose track of these scenarios. I remember I heard a story once where somebody wrote the date of prescription for a claim on a yellow post-it note and put it on top of the file and put the file in the cabinet, but failed to transfer that info into a separate diary, and obviously that claim prescribed in the cupboard. So it's just important to take those steps, and because as he goes to the point 1, there's no condemnation. So I think that's the presentation on prescription. Hope it helps. Thank you.
Because most people in afford investing, paying attention to the details on off regulations.
Not sure I'm following the question. Could you read it out loud one more time?
Poverty seems to contribute largely to the climate impact based on the preferred building methods and materials. Does the act make any provisions with the 5-year plans? Because most wouldn't afford investing, paying attention to the details of the regulations.
So, I mean, I think it comes down to, let me just stand up here. I appreciate obviously that most companies, come in different shapes and sizes, and some are in a position to budget more for the appropriate planning and infrastructure to address climate change initiatives and sustainability policies and the like at a more formal level. From a smaller operational level, it would just be a function of trying to, as a supplier to a bigger organization that has that kind of capacity, to address carbon choice of materials and processes. I mean, even small things. I mean, we're a services organization. We don't generate carbon through the operation of the advice that we render, but we do have a building that we occupy. And for example, we're trying to look at alternatives in terms of energy choice. And these are things that we can report to our clients on. Equally, as a smaller operation, these are things that you could, to your larger contracting companies, say, for example, I have a full recycling program, or these smaller initiatives feed in ultimately to choice of service provider, who's a better choice, and so on and so forth. I don't think that there's any clear guidelines in that regard at this stage, and I don't think it plays any role in the 5-year budgeting. That, as Natalie said, it's pushed down, and really will only apply to the larger organizations that are within the sectoral determinations in any event. I hope that answers the question. Unfortunately, Natalie had to leave because she had a 6 o'clock appointment. We've covered the Q&A session, which took us up to 6 o'clock. I'm very pleased to say that we've managed to cover the material in the time that we've been allocated. And I thank you for your interest and for your attention throughout these talks. I hope that you come away with at least some insights and some thoughts that can take you forward strategically. I want to hand over for concluding and farewell remarks to Avi, and a word of thanks from me to him, to Koleko, and to SAICE for partnering with us today. It's always good to have relationships and to collaborate and to speak to one another and to meet one another. So I encourage those of you who have attended remotely, if we ever do anything like this again, to come and join us for a drink next time, because that's what we're going to do now. And Avi, over to you. Thanks, everyone.
All right, thanks, Tom. Thank you, everybody. My name is Avi. We always look at lawyers as the bad guys, but Werksman, thank you for being the good guys and providing this platform and providing this workshop for free and not charging our SAICE members for it. So we appreciate it. Tom, thanks for helping out with the logistics of this and also for the CPD accreditation, and obviously to the rest of your team, Tom. And obviously all the audience, thanks for coming online, and those here and those of you who are here physically, thanks for coming. For those online, please join us for the next one. We'll advertise it soon, hopefully sometime early next year. If there's a specific topic that you want, do reach out to us. For those of you in the room, let's go get some drinks. Thank you. Bye.